I reached out to two legal experts for their interpretation on the effect of Issue 1 on parental consent. Dan Kobil is a professor teaching constitutional law and criminal procedure at Capital University Law School.
I think it's very likely that if it is challenged, Ohio's law would be interpreted in much the same way as the U.S. Supreme Court interpreted Ohio's law under Roe versus Wade. We have to remember that in 1990, the U.S. Supreme Court actually upheld Ohio's parental consent law because essentially it said that it was related to advancing the interest in protecting a pregnant minor's health. It talked about the fact that parents could contribute vital knowledge about a minor's medical history and so on. So it did uphold the law as long as Ohio had an option for a judicial bypass in the handful of cases where perhaps there has been parental abuse or the child would be subject to some consequences that would be quite troublesome to the minor. So the bottom line is, it was upheld in 1990 by a U.S. Supreme Court that I would say it's fair to conclude was more liberal than the Ohio Supreme Court is today. So if this were to go up there on a challenge, then I think it's likely that the Ohio Supreme Court could well rule that the parental consent law is a least restrictive means to advance the individual's health, which is what the amendment requires.
And on that question of a woman's health, I mean, the amendment specifically talks about individual, not woman. And so a lot of people are concerned about that opens the door for parents to be taken out of the process, because that individual could be a minor and not a woman.
Well, to be honest with you, with a plethora of constitutional rights are granted to people. For example, Ohio's right to bear arms is given to people. Children are people, but we don't give 10-year-old guns, and they are not allowed to buy guns. So that argument that the word individual means that any child of any age will be able to exercise the same rights as adults simply begs reality. That does not happen. The same is true with free speech. Children do have a right of free speech, but when they go to school, it's much more limited than what adults have.
Mark Weaver was a deputy attorney general under Republican AG Betty Montgomery and has also taught constitutional law. He's also a crisis communications expert and advises GOP candidates.
It's hard to tell what's in this constitutional amendment because there's a Lake Erie-sized loophole when it says it allows for an individual's right to make reproductive decisions, including but not limited to abortion. And by adding those words, but not limited to, the drafters are saying there's a whole raft of other rights that we're creating that some judge down the road will tell us what it means, but the voters won't know right now.
And I want to get to that, but I want to ask you too, the analysis also says the parental consent statute would certainly be challenged on the basis that Issue 1 gives abortion rights to any pregnant individual, not just a woman. Do you think that kind of challenge is likely, and how would Ohio's laws fare under a challenge like that?
It's important to remember that one of the key forces behind this amendment was the ACLU, and they have challenged parental rights legislation all around the country. So we know they're motivated to trample on parental rights, particularly on issues like this. And so how this will be ruled upon by the courts is hard to say, but we do know this: Constitution always prevails over state statutes. So no matter what the General Assembly passes, if a judge says it's contrary to the state constitution, the statute has to be struck.